Another comment you made in your reasons for the decision is that you defined routine engineering, and you mentioned here that it appears to have been the subject that has caused more controversy. As you put it, it's divided experts more than any other. So
Yeah.
why is that? Why do you believe that?
Well, routine engineering, standing by itself without benefit of a statutory definition, is it's pretty routine. It's pretty there's nothing unusual about it. That's why that people disagree over it. I think it's high time that they looked at the meaning, looked at the definition of routine engineering as including aiming at at least a result that is not predictable.
Well, the odd thing is you rendered this decision as Chief Justice in 1998, is that right?
I think so, yeah.
It still persists today. So I would say that that expression is equally as true in 2017 as it was in 1998. Let's explore a little bit further. Chief Justice Bowman, you have provided tremendous clarity on this subject. You've went on, this is the second part of your explanation about routine engineering, and you've described it this way. Briefly, it describes techniques, procedures, and data that are generally accessible to a competent professional in his field.
Yeah.
Seems to me that the underlying meaning of your decision would have required a great deal of thought in coming up with that.
I don't remember whether I did any thinking or not, but I can assure you, yes, I did.
Yeah.
And remember that routine, I meant, was intended to include techniques, procedures, and data. In other words, methods and information.
Information.
Yeah.
All right. So again, I'm going to describe what's happening. I mean, as a tax practitioner, with the Sheldon Group, of course, we have many of these discussions in various jurisdictions in Canada. Through the Tax Court of Canada, we argue these matters quite routinely, and we're hearing this both in the court and we're hearing it from CRA, that routine engineering is being regarded as the actual techniques that were used. You resolve the problem using that technique. Now, what you just said was data is information. Data, by extension, you would say, is knowledge.
Yes.
So if we were to take the last term, data, and isolate it for a moment, would it be fair to say that part of, not all of, but part of routine engineering would be the knowledge that's generally accessible?
Oh, of course. That's what data means.
That's what data means. But that's ignored. So one of these issues that we're seeing that, is regrettably happening in the courts where proper recognition isn't being given to eligible activity because of the fact that data is being ignored. One of the points that we have made is that the definition for routine engineering must be supported by what would be akin to the proverbial three-legged stool. You have techniques, procedures, and data. And without these three supporting legs, the stool would topple, would it?
Yes, because the third leg is an integral part of the stool.
That being said, routine engineering ought to never be identified as techniques that are known or techniques that are generally accessible. It must be that not only can it meet tests 1 and 2, but test 3. In general terms, would you say that if a company performs experimental work that results in knowledge that's not generally available, that would be constituted as an advancement?
Yes, I think so.
That equation is incomplete in the vast majority of situations where CRA is taking a position to deny a claim because of the fact that they're simply clinging to techniques and procedures. I'm not saying 100% of the time, but if they're not taking the time to consider whether or not the specific knowledge that's been gained by a taxpayer was generally accessible, and they're only looking at techniques and procedures, I would suggest that there is some misinterpretation of your decision.
Yes.
How do you feel about your decision being misinterpreted by the CRA?
Over 17 years of being a judge, I am not surprised at seeing my decisions sometimes being misinterpreted.